I already knew it was going to be a guilty verdict. Anytime the jury comes back quick, that's not good for the defense. I'll tell you, not in a murder case. I was actually shocked that they came back that quickly. Sometimes you go into a trial and it's just rock solid evidence against your client, and you know that, and you're saying, how long can we keep the jury out? Like, how long can you keep them deliberating? But in a murder case that takes 6 weeks to try, and the jurors have been sitting through all of that evidence, to deliberate that quickly in under 3 hours and come back with a verdict, you're walking in that room, you know it's a guilty verdict. There's no way they're coming back not guilty in 3 hours.
Is it a
There's no way they're coming back hung in 3 hours. So one of the jurors actually came out and did an interview, took an initial vote, and 9 jurors were for guilt, 2 jurors were for not guilt, and 1 juror was undecided. And he said, we went through the evidence, and 45 minutes in, all 12 guilty beyond a reasonable doubt.
There were 2 at that point before going and deliberating the jury.
Yeah, they said they said, look, we felt like the prosecution is not beyond a reasonable doubt. And they just start going through the evidence. But according to this juror, 45 minutes into deliberations, after we started going through the evidence, it was like everybody, we took another vote and it was 12 guilty. But he had to take the stand, Brian. But he did not do a good job when he was on the stand. He had to take the stand. You know, one of the juror that came out and did the interview, he said, look, when Murdaugh took the stand, the case was a wrap right then. They said, well, what do you think about his crying? He goes, he didn't cry. I was sitting as far as you're sitting from me, Brian. The juror said, I'm sitting away from Alex Murdaugh. And he didn't cry. All he did was blow snot. Right. He's like, I was sitting that close. Not a tear welling up in his eye. And I've seen a lot of defendants, when you get on the stand, it's the decision to cry or not to cry. And I'm going to tell you, if you choose to cry, it better be real, because jurors are watching. Like I said, that juror who got interviewed said he didn't cry. All he did was blow snot. And this was what was unnatural. You know what you do when you fake cry on the stand? What I see defendants do? They bring the tissue to their eye as they're dabbing the tears right at their eye, right? And that's because they can't generate the real tears to come down their face. So they're dabbing their eyes. But you couple that with the other thing he was doing. The juror said all he did was blow snot. If you watch his testimony, snot is dripping out of his nose. I mean, like a string just dripping down for seconds at a time, 5-10 seconds, just hanging from his nose, dripping onto his suit. And then he grabs his tissue and dabs it. And I say, okay, this is theatrical. It's melodramatic. You're trying to show the jury that snot's falling out of your nose. So you're not even cleaning the snot that's about to fall onto your suit, right? It's just dripping out of your nose. Yeah. You're letting it happen, then you dab it. But when it comes to your tears, you're getting those right away. Well, and to me, I said, this is fake crying, and jurors don't buy it. His lies just nothing was making sense. So he did himself no favors, and I actually don't think he did a good job on the stand. The number one question he had to explain away was, why did you lie to police about not being at the dog kennels with your family? And it was only in November when they finally downloaded his son Paul's phone and they found a Snapchat where his voice was there. And the juror said when he got on the stand and admitted that that was his voice and he was there, Rap City. Like, his only saving grace would be to say that's not his voice on there, but I guess he couldn't say that. But he had to come up and explain, why did you lie about it? And, you know, I said, man, yeah. His defense attorney said, is that you down there at the dog kennels? Yes. Did you lie to police about it? Yes. Did you lie in your follow-up interview with police about it? Yes. Why? And this was the pivotal moment. And he didn't have a good answer. All he said was, my drug addiction, coupled with police questioning me, coupled with having just seen my wife and son's body, all that together, I was paranoid, and I'm sorry that I lied, but I did, and I'm sorry about it. And I said, okay, well, that's not a good explanation.
Thomas, thank God that his son had that little Snapchat clip. That was a big piece to this case, because obviously it proved Murdaugh lied.
It was a huge piece in the case, and that's because he filed a notice of alibi back in November. Right. And so as a defendant, you file a notice of alibi. If you're going to put on an alibi defense, you can't spring that on the prosecution at trial. And what an alibi means is you were not where the crime took place. And you're going to bring in alibi witnesses because you give notice to the prosecution so that the state or the government can then investigate and be ready to combat your alibi defense. And so he basically filed an alibi defense saying he's not there, and then it comes out that you were there and that you've been lying to police about it for a year and a half. Yeah. That was, to me, an insurmountable hurdle. If not for that, there was a lot of, I'm surprised the jury came back as fast as it did. I thought there was some reasonable doubt there, but jurors don't like defendants that lie. And when he took the stand, the whole jury thought he was lying. The judge, even today at sentencing, said, basically, what you were saying was not credible on the stand, and the judge said 99% of this people who watch the trial know that you weren't credible on the stand. And one thing the judge pointed to was, how could you say that this was just another day in your life, that you were just having fun with your family when, number one, your father is on his deathbed. He's switching to terminal illness. Number two, the CEO at your law firm has just confronted you at work, that they know that you've been stealing client funds. They want to know about it. And number three, you also have this pending lawsuit with the discovery being requested by the civil attorney on the other side, which is going to expose all this financial fraud you've been doing. And so with all those things combined, how can you sit on the stand and say this was just another day?
Well, I agree.
You know, it was just a good day. And the judge said, I found that to be completely not credible. Yeah. And the explanation for the lie, it just did not pan out. You know, I said, look, what's your reason for lying? I was on drugs and I was paranoid. Okay. And I think this is what the judge said. This is what the prosecutor said in closing argument, especially in rebuttal. I think Creighton Waters hit it home in rebuttal. I didn't like the initial closing by the prosecution, but he goes, it doesn't matter if you have some pills in your pocket. That's what he was saying. I had pills in my pocket when I was being interviewed by police. I was paranoid about that. He goes, when your wife and son have just been murdered, you don't care about the pills in your pocket. You're not caring about any of this other stuff. You tell them, I was there. I saw him minutes before I just left. You make sure you tell police that. You don't sit there and say, I'm paranoid. Now I got to cover my tracks. And that right there was, you know, the juror who got interviewed, they said, look, the timeline was real tight for him to get all this done. To shoot them, to dispose of the weapons, to wash the blood off of himself, to change his clothes, go to his mom's. All those things combined, there wasn't a lot of time. And the juror said, we think that there was just enough time to get all that done. The other damning piece of evidence that was really hard for him to explain away, which they had no explanation for, is his wife's phone was basically out off the road, like it was thrown out the window. And it looks like that's the path that he drove to his mom's house after the murders happened. And so it's like, how did the wife's phone end up out there? It was very easy for jurors to find, and what the prosecution argued is that he tossed it out the window.
Right.
Okay, so that was an inexplicable fact. And look, there was a lot of things in the investigation that weren't done right. And that's defense attorney 101, attack the investigation, all the things that they could have done that they didn't. And I'll tell you, that happens in every trial. And prosecutors are always like, God, I wish the detectives did this. I wish they did this. I wish they didn't do this. Why did they do that? We're going to have to explain all of that away. We deal with that a lot because detectives, most of their cases, if they do everything right, the guy does not go to trial. And if they do a lot of things wrong, a lot of times the guy does not go to trial. He gets a better plea deal. And only once in a while does a detective's case get put on trial where they see how a defense attorney rips them to shreds on everything that they didn't do, right? And that detectives learn from that. But they go to trials are few and far between, and a lot of detectives, they can go far into their career. This SLED team, these are very experienced detectives, and they did a lot of things wrong. But at the end of the day, the detectives aren't on trial. It's Alex Murdaugh. And despite the gaffes in the investigation, the things that they could have done that they didn't, the jury found it was guilt beyond a reasonable doubt. And why? Because he lied on the stand. But he had to take the stand. He just didn't do a good job.
It was a Hail Mary. He had to knock it out of the park.
Well, yeah, you have to get up and explain away this lie. Once the
Yeah.
prosecution did it, and I said this, I go, when I saw his first explanation for why you continued to lie, he goes, oh, what a tangled web we weave. But once I lied, I continued to lie. And the defense attorney was just silent for a second. He actually just dropped his head. And I was like, I'd be thinking the same thing. I go, didn't we prep better than this, Alec?
Yeah,
I mean, we prepped your testimony for 3 days. This is what
Yeah.
you're doing on the stand. And here's what I say. You take the stand, put yourself in the position of, if you were innocent and you were being accused of butchering to death your wife and son by shotgun and rifle, and you're on trial for it, and the real killers are out there, and you're standing accused like case is going to be closed on me, you're indignant on the stand. And I saw none of that from him. Why am I on the stand? Why am I being tried for this?
Course.
I would never do this. How am I going down? But none of that, and like this indignant of, this is outrageous that I'm being charged here, right? There was none of that from him. And that was unnatural. And even the crying theory of defense that they put forward is that because his son killed this girl in a DUI boating accident a few years before, back in 2019, that there was a civil lawsuit. But because his son had not been brought to justice, I think the criminal case was still ongoing.
Right.
That there's some vigilante, that there were a lot of threats to his son. And that's what he was trying to tell the police, that was what happened. And that wasn't an implausible 2 consecutive life sentences here. I was surprised how quickly they sentenced in South Carolina. They were ready to sentence right after the trial. They said, oh, the judge delayed sentencing to see if any victims wanted to speak at sentencing. I'm like,
Yeah.
As soon as the verdict comes in, you try. I was like, there's a lot of
Yeah.
jurisdictions where sentencing gets kicked out a month or two so that
Yeah.
the defense can present mitigating evidence, not just about the trial or you're confessing, but about his entire life leading up to that point. You're allowed to
Yeah.
do that. But I was surprised that South Carolina, they get right down to business, don't they?
Yeah,
I thought the deliberations would be a little bit tougher than they were. But I think the jury went back there and they're like, he couldn't explain away his lie. That's what it really came down to. So I actually thought this might be a hung jury. I did. I thought there was enough because, look, you have the two-shooter theory. Why would a guy grab his shotgun and then also grab a rifle when this is going to be a very quick killing? But I guess the jury said, well, he's trying to make it look like two shooters. That's why we have a jury system there.
I get it.
I also said, about the blood splatter. And these are close-range shots. How are you able to wash all of the blood off of your body that quickly to where you're already on the road to your mom's house? I was like, okay, that's a tough one for the prosecution to overcome. The motive, I thought, was very questionable. The prosecution's whole motive in closing was the storm was gathering and it was about to rain, and that's why he killed his wife and son. But look, he didn't stand to benefit financially from it. And one thing that I thought the defense did really good in closing, which they opened the door to the roadside shooting, which was a huge mistake by the defense. They didn't mean to do it. But the roadside shooting coming in, where he actually tried to have a drug dealer kill himself, so Alex Murdaugh's life insurance money go to his other son, I think the defense made a good point. Go, look, that's when the storm is coming, you don't go kill your wife and son for it. And look, the guy tried to organize basically his own assisted suicide 2 months later, way before he was ever charged in this case. He still wasn't even charged in this case. He wasn't even thought to be the main suspect really in that case at that point. He tried to kill himself. That's what you do when the storm is coming. And it's hard for a juror even to believe, like, you could go kill your son and your wife in this fashion, especially with all the testimony that came out. Everybody who testified in the trial said Alec loved his wife. He adored his wife, that they had a great relationship. So to me, I thought jurors would come out and go, the motive doesn't make sense. The timeline, and if you really look at the timeline and dissect it, it's real tight for him to get everything done the way he's done. A lot of things just didn't make sense. But at the end of the day, when that Snapchat video came out and put him at the scene just minutes before the crime, and his wife's phone is sitting out there in the woods along the same path that he was driving, and then his explanations when the prosecutor got him on cross-examination said, well, start explaining all your steps that you took with your cell phone before you went to the house. And Alex Murdaugh was like, well, I think I did take a nap. Well, your nap would have had to have been like 5 minutes. He goes, maybe it was like a 30-second nap. I don't know, 10-minute nap, 20-minute nap. It's like, look, man, like you have, like the prosecutor said, You're explaining away everything that you were prepared for and everything you're not prepared for that I'm asking you. You don't have an answer for. All of a sudden, your memory gets hazy on it. But I was surprised. I thought the jury would sit out for the weekend. I mean, at least in trials where it's rock solid, the jury sits there and goes, let's at least go through all the evidence with each other again and talk about it. But to come back that quickly on a case that took 6 weeks, wow. They went in there, and it wasn't hard for them to make their decision. F. Lee Bailey, a famous defense attorney, he said when you're talking to a jury, you're usually talking to one person, maybe two. And that's because there's a four-person. As attorneys, we usually bet on this during the trial. Which juror do you think is going to be the four-person? And the strongest personalities emerge. And there's one person on one camp and maybe a second person in a second camp. And they're fighting against each other trying to sway the jury. And a lot of other jurors just kind of go along with it.
Yep.
What was really funny in this trial is, I don't know if you knew this, but it was the day before one of the jurors got dismissed and an alternate got put in. And she was dismissed for juror misconduct. And what the judge said was, look, they've brought to our attention that you've talked about this trial to other people outside of the jury. And some of the other jurors said you have mentioned the trial to them. You're not supposed to do that. I'm not saying you did anything intentional, but you need to be off the jury. And what came out is her discussions with the jurors was she thought Alec was not guilty. So the defense team lost a really, really strong juror for them. And she might have been one of the crazies, because the funniest thing that happened when they went to dismiss her, they brought her in. They said, look, we're dismissing you from the jury, not saying you did anything wrong, but we got to protect the sanctity of the trial. Is there anything that you left in the jury room that you need to get? And she goes, yeah, I got a dozen eggs in the jury room. And everybody started laughing. The judge says, eggs? Like, you have a dozen eggs? She goes, yeah, I have a dozen eggs back there in the jury room. And he goes, well, do you want to take him with you or do you want to leave him here? She's like, I'd like to take him with me. And so right there, everyone goes, this might have been that cuckoo crazy juror that could have hung the jury, who could have held out over the weekend for the next week, to where the jury finally comes back and says, Judge, we can't make a decision. But I'll tell you, when a jury hangs, they make that jury deliberate in a trial like this for a week or two. And they basically keep bringing them in, go, you have to come to a decision one way or the other. So there's a lot of pressure. And there has been trials where jurors have succumbed to that pressure, and after the fact said, I didn't want to go guilty, but they were all just riding me so hard back there that I changed my vote.
Well, it's...
If that juror stayed on, she might have been the stubborn, not guilty that Alex Murdaugh needed. But if you get a hung jury, it doesn't mean you're acquitted. Mm-hmm. You need 12 not guilties. It means it's a hung jury. That means you're going to get a retrial. And I'll tell you what, a retrial is never good for the defendant. Because what happens is the prosecutors, it's basically having a dry run, right? It's like, hey, I see everything that we did wrong, that we could do better. We get to talk to the jury afterward and go, hey, what questions did we not answer for you? What was the reasonable doubt in your minds? And the jury tells them, and they go, okay, round 2, we're going to put on a better case this time. And we have Alex Murdaugh's horrible testimony from round 1. Should he choose not to take the stand in round 2, we have that. And if he takes the stand and tries to better his story the second time around, we have that. So... they were going to try this case again if it was hung. Well, before the break, you said that the death penalty was on the table, and I disagreed with you.
Yes, let's talk about that.
And so what I wanted to explain to you is that the judge, here's exactly what Judge Newsom said. He said, look, the prosecutors did not seek the death penalty in this case. And I don't disagree with their decision, because that's the inner workings of the prosecutor's office and what they do. That's basically what he meant by that. And what happens is, if prosecutors are going to seek the death penalty, there's a whole machinery that's going to happen that comes along with it. You have to file a death penalty notice. There's certain litigation that's going to happen because of the death penalty. The sentencing is going to be different. Mm-hmm. There's going to be different things in the trial. And the prosecutors chose not to seek the death penalty.
Right.
So because of that, the judge could not now impose the death penalty as sentencing, go, I disagree with prosecutors, I'm sentencing you to death. What Judge Newsom said is, the prosecutors didn't seek it. I'm not going to disagree with that decision, but I'm going to say this. In South Carolina history, we've given out the death penalty a lot to people for lesser conduct than what I saw in this trial. And what he hinted at was, I'd give you the death penalty here. And then when he laid out his sentencing considerations about Alex Murdaugh being a lawyer in the community, Alex Murdaugh being a prosecutor in that community. Not only was he a civil plaintiff's attorney, but he also served as a part-time prosecutor in the community. If there was probably a conflict in the DA's office, he'd be one of those guys who would come in and prosecute cases. Given his family's history, his father, his grandfather, his great-grandfather, all being part of the prosecution and law enforcement in that community, that he should have been held to a higher standard. Then couple that with the fact that he came in under oath, lied on the stand. It was a completely incredible testimony. And I'm glad that Judge Newsom said that, because people, I wondered what people thought, but when the judge is sitting there, he goes, man, I thought you were full of baloney when you testified.
Right.
And you're stealing from your clients. You admitted to that. Like, you violated your oath as an attorney. And then... look, I'm not going to tell you to confess because I know you need to appeal. So you got to maintain your actual innocence for you to try to appeal this thing forever, right? I don't expect that. And in my 22 years, I've never had a murder defendant come out at sentencing and go, all right, now that I've been found guilty, this is what was going through my mind that made me commit the murders that day. But you have a chance to do it. Do you want to say anything? And Alex Murdaugh, same as when he was on the stand, no indignance. If you're really innocent, wouldn't you be indignant after the trial? Like, you're being sentenced? You're like, Judge, I'm innocent, not Judge. I mean, it's just like basically for the record, I'm innocent, just so my appeals can take place here. And that's what Judge Newsom said. Like, you're not taking any responsibility here. And I understand that you have your appeals, but maybe this is your chance to take some responsibility. What say you? And all Alex Murdaugh did was get up and say,
lie.
Well, he said, I'm innocent and I would never hurt him again. And then he even asked Murdaugh another question. He goes, what did you say on the stand again? Remind me. He's like, what a tangled web we weave. Right? Yeah. He's like, what did you mean by that again? He goes, it was just such a bad testimony from him. But he repeated, he goes, well, once I lied, I had to continue to lie. And he's like, well, no, the weave was a lot more tangled than that. You've been weaving it for quite some time. And so when the judge handed out consecutive life sentences, meaning you're never getting out of prison, and these are consecutive life sentences, I wasn't surprised by that. He basically said I would have given you the death penalty had you, had the prosecution sought it. Let's talk about this. Now that he's gone to the trial, now that he is maintaining his innocence, we're going to have the appeals.
Yep.
And there were a lot of missteps made in this trial. There were a lot of issues that I saw brought up, even in the closing argument. I saw a lot of improper argument there. Is it going to be enough for an appellate court to overturn his verdict?
Right.
Maybe not, but
Yep.
there were a lot of mistakes made during the testimony, improper questions. I think that, what everybody's really harping on is the bad act evidence of his financial crimes against his law firm, that could be an appealable issue. And it is, but I think he kind of ruined that appeal by taking the stand himself, because what happens when you take the stand as a defendant, your credibility becomes an issue.
Sure.
And, of course, you stealing from all of your clients at your law firm has a big evidence of your credibility, and it goes towards that. So now that he did that, I think the judge's decision to allow the prosecutors to get in that as to motive, because that didn't really make sense to me. That you're stealing from your law firm, so you're killing your wife and son to buy time. Yep. That to me, I haven't seen any appellate case law considering you admitting someone's past financial crimes against them to prove motive when they're not really going to make money off of the thing, just to buy time. So that was going to be an issue on appeal, and it still will be. And improper closing argument. The word liar was thrown around a lot. And I understand he admitted lying. So maybe that could be a difference. But as a prosecutor, you're not supposed to judge the credibility of the witnesses. The jury. So you make arguments couched like this. You don't say, he lied, he lied. That's what Creighton Waters is pointing at him. He lied, he lied. No, you get up there and you say, look, he admitted that he lied about this. He admitted he lied about this. And now he's on the stand. Sure. This is the story he's telling you. And do you find his evidence credible? Because he's inconsistent here, he's inconsistent there. But for when a prosecutor gets up there and starts calling a witness or a defendant a liar on the stand, that's usually a big issue on appeal. And the reason why this becomes even a bigger issue is because this was a circumstantial case. I know the judge said the evidence was overwhelming, but really, the evidence wasn't overwhelming as, like the judge said, I've had people who confessed to police and then still maintain their innocence at trial and at sentencing. And they confess. We have them on a recorded confession. Here you don't have that direct evidence, so it is circumstantial.
Understood.
And appellate courts are going to be looking at this going, this guy got life without parole. What were the problems in this trial? What were the issues in this trial? And we're going to look at it. And it could not be the first appeal, but maybe a federal court 5 years down the line, 10 years down the line, 20 years down the line can look at this stuff, and you have a federal judge reverse it. And I've seen it happen a lot. I've had cases where I was still in law school before I went to law school when I was a prosecutor, came back on my desk from 25 years ago going, federal judge just overturned this because of problems here, problems there. And look, it was a big thing for the defense. Even the defense's mistakes are going to be appealable issues, right? The defense opened the door to the roadside shooting. They didn't plan on doing that. They didn't want to do that. His appellate attorneys down the line are going to go, that's ineffective assistance of counsel, the fact that they were dumb enough to do that. Things that should have been done in the defense investigation that was not done, right? The evidence that they should have tried to get that was not done. So whenever a person goes to trial, whether you get the death penalty or not, whenever a person gets to trial, they preserve their appellate rights. And that's why I always explain to people that when I was a prosecutor, and I explain to prosecutors now when I'm negotiating on behalf of my own clients as defendants, I go, look, you know as well as I do, that guilty plea on that paper where they come in and admit guilt, it's worth its weight in gold because they are waiving their appellate rights. We have closure on this case. This case is going to be litigated for a long time. And I watched the whole trial myself. I said, look, this guy, basically the jury said he's lying about this whole alibi when he got on the stand. But the evidence in the case, I mean, there's a lot of things about this case that did not quite make sense. But look, a jury unanimously says beyond a reasonable doubt you committed these murders. Okay. If it was a clean trial, if it can be held like that on appeal, that it was clean, there was a lot of things that were not clean about the trial. And I don't mean it was a dirty trial. I mean, as an attorney, as a judge, you're trying to make the trial as clean as possible. I think the Judge Newsom, sometimes he deflected issues because he just acted purely as a referee. Sometimes when a defense attorneys object or don't object, okay, if they object, that preserves certain issues for appeal on a standard of review, and it becomes a lesser standard on appeal. But there's some things that attorneys don't object to that are still going to be reviewed on appeal and post-conviction that are held for plain error, and a judge needs to have his eye out for that. And I think sometimes he sat back and just acted purely as a referee sometimes, as if he's just, if you don't object, I'm just letting everything go. I want to say one more thing about the appeals process, though, is the number one reason why trials are overturned are jury instruction issues. Okay. And that has nothing to do with anything that happened in the trial. It has nothing to do with the investigation leading up to the trial. It has nothing to do with the litigation or objections. If there's a jury instruction that was wrong, then the case is going to be overturned. Now, I'm not sure how South Carolina does their jury instructions or not, but I was very curious about the entire process there. Number one, you read the jury instructions to the jury after the closing arguments of both sides, right? So the jurors are not even told what the law is until after closing arguments. Number two, you got these attorneys in closing arguments. They were commenting on the standard of reasonable doubt like crazy. The prosecutor got up there and said, hey, you know, you got beyond a reasonable doubt is kind of like when you're making the most important decisions in life. That's what the defense said. And then you have clear and convincing evidence in civil trial and preponderance of the evidence. And look, if you have one reasonable doubt, I said, man, this is not allowed in most courtrooms around the country. You cannot quantify reasonable doubt. And they were doing that on both sides of the aisle right there. When what it is a legal instruction is going to come out and says, this is the definition of reasonable doubt. This is what you take back to the jury deliberation room. This is what you do. You don't have attorneys start saying, well, if it's an important decision, if you would hesitate in making the decision, that's reasonable doubt. I said, this is nuts. I mean, Creighton Waters got up there in his rebuttal and goes, oh, Blanca, the housekeeper, guess what? I met her in federal prison years ago. I recognized her. I said, this is not evidence in the case. What are you doing, man? So I looked at a lot of this. I went, man, I'm seeing errors all over the place. And I thought Judge Newsom should have interjected without an objection from the other side and said, hey, stop commenting on reasonable doubt right now. Okay? Stop talking. Prosecutor, you don't say that you met this witness years ago in federal prison, that you know her somehow. Like, what are you doing? Talk about the evidence in the case. Stop calling the defendant, his testimony on the stand, a lie. Like, you can say where he admitted lying, that he's a liar because of the admitted lies, but don't say that his testimony, the jury determines whether that's a lie or not. So all of those improprieties, maybe it's not enough to overturn a verdict, but those are errors in the trial. I'll tell you, they could be deemed harmless errors, but there are errors, and no trial comes out where there's nothing called an error.
All right.
Story for them to put forward. It really wasn't.